the Honorable President can, my lord, seek your lordship's opinion on that. Please have a look at, my lord, how this question has arisen, but will definitely arise. And I am showing the view in Tamil Nadu, my lord. I am conscious it's not an intra-court appeal, but it's a view decided and legal view your lordships can, my lord, as held in the 2G case, interfere with. My lord, please have a look at, my lord, first, page 12509. Volume 5.31. We, my lord, examined this. We went to this.
The question is whether a petition under Article
32 or 226 would be maintainable in the context of the power or function, my lord. Power is a little harsher word. Function exercised respectively by the Honorable President of India and the Honorable Governor under Article 111, Article 200 and Article 201 of the Constitution of India.
An exercise by President or Governor.
Governor respectively under Article 111 and 201 and by the Governor under Article 200. So this, my lord, was not, my lord, none of us assisted your lordships on this. And I am the only one, my lord, who is going to make submissions on this. Others, my lord, would not trouble your lordships, my lords.
What is the page that you have referred to just now?
12509.
That's enough.
Para 367. Lord, PDF would be 336. In that volume, my lord. My lord,
Paragraph 367.
367.
Yes.
The Honorable Bench is pleased to summarize the conclusions. Kindly come to A. Because this will have to be examined, my lord. Otherwise, my lord, questions will keep on arising. Which question is already, my lord, put for your lordship's kind opinion. Your lordships, may I read, my lord? A. Where the governor reserves a bill for the consideration of the president in his own discretion and contrary to the aid and advice tendered by him by the State Council of Ministers, it shall be open to the state government to assail such an action before the appropriate High Court or this court. Such a challenge can broadly be made on the following grounds. So first, it can be a 32, it can be a 226 petition, and these are the grounds. Please read. Where the reservation is on the ground that the bill is of a description falling under the second proviso to Article 200, it may be assailed on the ground that the bill or any provision thereof does not so derogate from the powers of the High Court so as to endanger the position which the court is designed by the Constitution to fill. The governor, while reserving a bill on this count, shall be expected to provide clear reasons and also point to the specific provisions of the bill which, in his opinion, attract the second proviso. This is, my lord, difficult part. This question being purely of a legal nature would be completely justiciable. My lord, meaning that, I'll come to that, my lords. And the competent court would be, after a proper adjudication, fully authorized to approve or disapprove such reservation by the governor. If such a challenge finds favor with the competent court, then, subject to other considerations, it would be a fit case for the issuance of a writ in the nature of mandamus to the governor for appropriate action. I'll come to that, my lord, whether a writ would lie against the governor, my lord, under the scheme of the Constitution. When your lordship examines governor's function or exercise of power under 356, my lord, presidential rule, failure of law and order, Article 356 provides for a contingency. That if there is a failure of law and order,
conditions on which the power can be exercised.
And your lordships would not be issuing a mandamus to the governor. Your lordships would be setting aside the order whereby the President's rule was imposed. Lord, further, then Roman 2, where the reservation is on account of the bill attracting any provision of the Constitution wherein the assent of the President is a condition precedent for the proper enactment and enforceability of such a bill as a law, such as under Article 364A2, or for the purpose of securing any immunity or overcoming any repugnancy that may exist qua a central legislation, then the governor is expected to make a specific and clear reference to the President, properly indicating the reasons for such reservation and inviting his attention, that is President's attention, as described in Kesare-Hind. Such a reservation can be assailed by the state government if the reference made by the governor either fails to indicate the reasons for such reservation as discussed above, or, please mark, the reasons indicated are wholly irrelevant, mala fide, arbitrary, unnecessary, or motivated by extraneous considerations. So not only petition would lie on these grounds, and when petition is filed, these are the considerations, even unnecessary, that it was not necessary. We feel it was not necessary. So we substitute our decision to that of the governor and direct the governor by a writ of mandamus. Further, then such a reservation would be liable to be set aside. This question, being purely a legal nature, would be completely justiciable, and the competent court would be, after a proper adjudication, fully authorized to approve or disapprove of such a reservation by the governor. Meaning, thereby, again, law is, if something is legal, it is justiciable. If such a challenge finds favor with the competent court, then subject to any other considerations, it would be a fit case for issuance of a writ in the nature of mandamus to the governor for appropriate action. So, my lord, it is kind of a advance ruling, my lord. Now, my lord, kindly see 12582 or 578, 12578. One two five seven eight. My lord, I'm sorry, 12513. My lord, kindly, my lord, see 12513. My lord, there is a time limit prescribed, and my lord, kindly see 12513. My lord, Roman 5. Doesn't my lord Justice Narasimha gets my lord's get. Where the governor exhibits inaction in making a decision when a bill is presented to him for assent under Article 200, and such inaction exceeds the time limit as has been prescribed by us in para 250 of this judgment, then it shall be open to the state government to seek a writ of mandamus from a competent court against the governor, directing expeditious decision on the concerned bill, as is the mandate of the Constitution. However, it is clarified that governor may successfully resist such a challenge on providing sufficient explanation for the delay caused. Lord, governor can't even be called upon, my lord. My lord, here, my lord, in substance, my lord, the court doesn't use the way in which, my lord, I am describing it, that Mr. President, you decide within 3 months. You better give your reasons. My lord, I have shown that. And the state government, if she doesn't do it, come to us. That, my lord, with profound respect, is not the constitutional scheme. A, 32 does not lie. 2, mandamus cannot be issued. And 3, it is not justiciable. Every question which is legal is not justiciable. Now, my lord, come to page 12578. And, my lord, this will have a far-reaching ramification. Therefore, my lord, after considered debate, my lord, at our end, my lord, the Honorable President decided that it's better that we know what is the legal position, and therefore we must request for the opinion of your lordships. My lord, 12578, para A, Roman 1. These are also, my lord, the penultimate para. These are the final directions. Where the reservation is on the ground that the bill is of a description falling under, my lord, that is, my lord, the same thing. And, my lord, I'll not. Same conclusions, my lord, are repeated. My lord, in the final chapter, my lord. I'll just, my lord, place my short note, and my lord, I can assure your lordships, I'll not read everything. But copies are given, my lord. I have prepared this. Lord, it would be volume 1.8. Lord, volume 1 should have been the Learned Attorney General's volume, but since mine was filed first in point of time, Lord, the numbering is accordingly given. Lord, I'll just broadly indicate and read only those paras which would assist your lordships, my lord, directly. Everything, my lord, is there, my lord, for your lordships to consider, and everything will assist your lordships. But, my lord, considering that I am, my lord, raising this issue with your lordship's permission at the end, and nobody else is going to, my lord, raise this issue, my lord. This is our collective work, my lord, which I am presenting before your lordships. My lord, first, whether a writ petition under Article 32 would lie at the behest of the state government, my lords. My lord, there are two objections, and based upon which, my lord, we request your lordship's opinion whether your lordships would entrust or empower the state government to file a writ petition, my lord, because you have to seek source of your right. This is the court given right, my lord, that you all right, you come to us. My lord, there are two objections. A, 32 lies when there is a violation of fundamental rights, and the state government as a constitutionally formed body per se cannot have fundamental rights. It may represent fundamental rights of others, but otherwise the scheme of the constitution is state government is repository of functions which is to protect the fundamental rights of everyone. My lord, a similar question arose even by an individual. My lord, what happened was the house was prorogued by the speaker, which was illegal, and one member of parliament approached your lordships under Article 32 of the Constitution, and the question squarely arose whether a 32 petition would lie. My lord, please come to, my lord, page 3 of my note. My lord, the bottom is the pagination. My lord, your lordships may bear one factor in mind, my lord. Kindly, my lord, this was, my lord, highlighted, but my lord, I feel, my lord, it could not be highlighted as much as we wanted to highlight it. My lord, there are chapters under the Constitution. Your lordships would find chapter 200, article 200 in the chapter which starts with legislative procedure. So please come to 196, my lord, article 196. Just above that, heading, my lords. 196, provisions as to introduction and passing of the bills. I'm not reading it. The legislative process starts with introduction of the bill. Obviously, it's a part of the legislative process. Then it goes up to Article 200. The legislative process culminates, ends when the governor discharges one of his choices out of the four, or the honorable president, on being reserved, exercise the proceedings, exercise the choices under Article 201. So Article 196 to 201 is a part of the legislative process. It has as much sanctity as proceedings in the House before in the House. And thereafter, the new chapter starts, procedure in financial matters. When a bill is involving issues with regard to financial bill, etc., etc. So, my lord, my first respectful submission for your lordship's assistance is that it is a part of a legislative process, and the question would be, can any part of it be subjected to writ jurisdiction on the ground that fundamental rights are violated? Please have a look at page 721. The bottom pagination, internal is 3. Ramdas Athavale versus Union of India. It was held that the validity of the speaker's decision adjourning the House sine die and later directing to resume.
Where are you reading?
Lord, I'm sorry, page 721. My note,
Yes.
top pagination is 721.
Ramdas Athawale.
Ramdas Athawale. What is 5? Yes, madam. It was held that the validity of the Speaker's decision adjourning the House, sine die, and later directing to resume its sittings cannot be inquired into on the ground of irregularity of procedure. The relevant paragraphs reads as under. It is equally well settled that Article 32 of the Constitution guarantees the right to a constitutional remedy and relates only to the enforcement of the right conferred by Part 3 of the Constitution, and unless a question of enforcement of a fundamental right arises, Article 32 does not apply. It is well settled that no petition under Article 32 is maintainable unless it is shown that the petitioner has some fundamental right. In so-and-so versus so-and-so, this court has made a pertinent observation that when a person complains and claims that there is a violation of law, it does not automatically involve breach of fundamental right. My lord, similar judgment is, my lord, I'm not, my lord, reading it, but where they say even private party cannot come directly to the court under 32, that there is a violation of law, because you will have to show
Unless there is a
violation of fundamental rights, my lord. My lord, kindly see, Lord, one provision of a constitution can bar jurisdiction of the High Court or the Supreme Court in another provision of the same constitution. Lord, that question arose when state of Karnataka came here in a 32 petition with regard to water dispute. And this honorable court was pleased to say that we have a separate article, Article 262, for dealing with intrastate water disputes. And therefore, you cannot come under 32. My lord, please come to 722. My lord, I am also saying 131 would also not apply, but I would, my lord, come at a my lord, at the end. My lord, please see, there are, my lord, this is Atmaling Reddy versus Union of India, where he was a man, my lord, according to, my lord, it appears, my lord, sponsored by, not sponsored, but put up by the state. Article 131 of the Constitution, which enables the central government or a state government to institute a suit in this court on its original side in certain cases, also cannot be invoked in interstate water disputes in view of Section 11 of the Act. In other words, the provisions of Article 131 of the Constitution have to be construed harmoniously subject to provisions of Article 262 of the Constitution. A petition under Article 32, hence, cannot be entertained by this court. Well, this is only for the limited purpose that one constitutional provision can also bar jurisdiction under Article 32. Now, my lords, may kindly come to para 7. Lord, the possible argument that we are coming here in a representative capacity because we represent the people. It's a quite possible argument and a permissible argument. They do represent the wish of the people. But question is, would that entitle them to invoke your lordship's jurisdiction under Article 32 of the Constitution? Because as I have already said, the solution lies elsewhere. 32 would not be maintainable. I am only on maintainability. Please have a look at para 7. It is submitted that Article 32 is a remedial provision meant for enforcement of fundamental rights under Part 3. A state is itself the state within the meaning of Article 12 and is the bearer of constitutional duties, not the holder of Part 3 rights. Therefore, a state cannot maintain a petition under 32. For the same reason, a state cannot use 32 to litigate fundamental rights in a representative capacity. Article 32 requires the petitioner's own Part 3 right to be in issue. So that's how the article is worded, that petitioner's fundamental right. My lord, your lordships have exempted this only when the concerned petitioner is unable to approach. My lord, workers.
On account of social and economic disputes.
Economic, my lord, and not to the government. Government cannot come. It's the duty of the government to protect them. Some non-governmental organization comes, some individual in a representative capacity comes. Now, please, my lord, come to Lord, directly page 725. My lord, I have cited judgments, my lord. I'm not reading them. Relevant part is highlighted. Sorry. Yes, my lord, 725. My lord, I have said that, my lord, kindly, I'll read para 13, my lords. In view of the above, a state which does not have any fundamental rights cannot file a petition under Article 32 for any purpose whatsoever. Permitting states to file Article 32 would amount to turning the scheme of Part 3 on its head. The center-state relationship is governed by Part 9, 10, 11, 12, and 13 of the Constitution. The disputes between the governments are dealt with in Article 131 of the Constitution. A state government or even the central government cannot invoke Article 32. But this would be very, very relevant. Kindly imagine a converse situation. Look, there is a law and order situation in one particular state, and such instances have arisen. Lord, I'm not giving a hypothetical example, but without naming the state, where there is eruption of violence. The local police is unable to contain violence, either because of inefficiency or because of inadequacy of the force or for various, my lord, other reasons. And if the central government says, and which it can say, my lord, under the Constitution, that you deploy paramilitary forces for protecting the fundamental rights of the citizens, and the state refuses to do that. Lord, I am putting a question to myself, can the central government file a petition under Article 32 seeking a direction of your lordships, directing the state government to deploy paramilitary forces, my lord? My answer would be, my lord, in the negative. It cannot be done. Yes.
But nobody is to.
No, he is rejecting my submission, my lord. So I'm saying, please don't do that. You will oppose every submission, but not now. That's simultaneous. Lord, now, my lord.
Yes, proceed.
He can never, my lord, disturb me without my consent. I refuse to be disturbed. Lord, page 725. Lord, bottom, Lord, this is.
Why are you getting disturbed if you can't be disturbed?
No, I'm just telling him that please don't do this. 725, my lord.
Yes.
Lord, this is American law, my lord, which I generally do not cite, but please have a look at, my lord, this. And therefore, I have not quoted in extenso.
Para?
My lord, at the footnote of page 725. In American Constitution law, it is settled law that the states cannot assert the rights of their citizens as parens patria and approach the Honorable Supreme Court of the United States under its original jurisdiction when the defendant is the federal government. My lord, states there, my lord, are quite independent. It's not a part of a federal whole. They have their constitution, they have their separate flags, they have their separate Supreme Court. They say that these are federal issues between the state and the center, and we would not kind of work as a headmaster between two fighting students. My lord, in main submissions, my lord, I ignored that, my lord, but we have cited American cases also, that where the federalism is of a different nature. There were questions of deployment of forces, my lord, in American courts. But they say that you cannot come to the Supreme Court for this. These are federal issues decided politically. We would steer away from such issues being examined at the judicial level. Now, my lord, para 17, I have said, my lord, and I orally paraphrase, I will not read it. My lord, I am coming now to Article 226. My lord, what would Article 226 entitle or empower the High Court to do? And let us examine each. Writ of habeas corpus, my lord, no question from in the facts of the case. Writ of certiorari it applies to, my lord, tribunals, quasi-judicial bodies, etc. Writ of prohibition, when some statutory authority is discharging some function, or constitutional authority is discharging some statutory function, non-constitutional function, in a manner which it should not, then it will be prohibited. The question cannot arise in the context of Article 111, 200 and 201. Quo warranto is not a situation, then only remedy